If it please, my Lord, I and Mr. Lutweza appear on behalf of the state in this matter.
Please, Your Lordship, I appear on behalf of accused 5, 10, 12, 13, and 14. Of course, we are not party to the application before court. May it please the court.
As the court pleases, my Lord, I appear on behalf of accused 7, 8, 9, 23, 25, 26, 27, and 28 in the main trial. As the court pleases.
As it please the court, my Lord, I appear on behalf of the 4th and 24th accused person in the main matter.
Mr. Gustavo, you are here?
My Lord, sorry for the meeting. I got a letter from the correctional facilities officers, a medical certificate which shows that Mr. Gustavo is in hospital at Late Boamba. If I may tender the medical certificate, my Lord.
Yeah, unless it's contested, there's no point. I'm saying unless it's contested, there's no point. And then the other persons appearing in person. Yes. And Mr. Shanghala, is it?
Judge, I'm also unrepresented.
You are not represented.
Excuse me, Judge?
You are not represented.
Yes, hitherto.
And then
Morning, Judge. Accused Montelulo here. Continue to appear as before.
in person.
Yes.
Yes. Well, the purpose of today is for me to hand down my judgment in the ex parte application of Mr. Shanghala, Mr. Tukulipi, James Atukulipi, and Mr. Mwatelulo. I will read through the judgment for purposes of transparency, and you'll have to bear with me. Right. This is an application by 3 of 28 accused persons in what is now come to be known as the Fishrot trial. That is the state versus Ricardo Gustavo and others. Case number 606 of 2021. The application is for the reservation of certain questions of law for the consideration of the Supreme Court in terms of Section 319, subsection 1 of the Criminal Procedure Act. In Van Wyk versus the state, which is the recusal judgment, I gave a summary of the charges faced by the accused persons. The accused are jointly and severally or with common purpose charged under various statutes read together with the Criminal Procedure Act on charges of racketeering, money laundering, possession and use of proceeds of unlawful activities and other offenses under the Prevention of Organized Crime Act, POCA, corruption, conspiracy, and other offenses under the Anti-Corruption Act, which I refer to the AC as the ACA, fraud, alternatively theft, tax evasion, and failure to furnish tax returns under the Income Tax Act number 24 of 1981, conspiracy to commit fraud or tax evasion under the Riotous Assemblies Act number 17 of 1956, defeating or obstructing the course of justice or attempting to defeat or obstruct the course of justice, unlawful possession of ammunition and under the Arms and Ammunition Act, Act number 7 of 1996, assaulting, resisting, or obstructing an authorized officer under the Anti-Corruption Act, and resisting a member of the police under the Police Act number 19 of 1990. The main or most serious charges are those under POCA and the Anti-Corruption Act, read with the provisions of the Criminal Procedure Act. As I said, therein several of the measures, about 42 of them, have alternative charges. The questions of law sought to be referred to the Supreme Court are listed in the applicant's founding affidavit. They are the following. Number 1, can a judge in a criminal matter who is faced with a recusal application leave to appeal a recusal ruling or a petition to the Supreme Court to hear a recusal, refuse to take any further action ancillary to the criminal case in which the judge is being asked to recuse himself or herself? And can such judge refuse to exercise judicial authority at interim other than case managing a criminal matter? Or does the recusal application leave to appeal a recusal ruling or a petition to the Supreme Court to hear a recusal impair his or her judicial authority to take action or make ancillary orders in the criminal trial? Question number 2, can a judge who is faced with a request made pursuant to Section 319 of the Criminal Procedure Act defer, hold in abeyance, or refuse to consider such request and exercise the discretion to reserve, state, record in the record, and transmit to the registrar of the Supreme Court the request when it is made? Does the lack of legal representation of the above-mentioned applicants in the criminal case number 06 of 2021 not amount to a violation, infringement, and negation of their fundamental wealth of the Namibian Constitution? And will the continued prosecution of them until the matter of their legal representation is resolved as outlined in the case of Luboya versus the state not amount to such violation, infringement, impairment, and negation of the right to a fair trial? Question number 4, does it not amount to a violation of the right to a fair trial and prejudice to the accused persons that pleas have been taken for some of the charges or counts in December 2023, yet the state made disclosure of some 30 files on 15 February 2024 of material information that was not previously disclosed, which, if such were disclosed, being the basis upon which the accused could bring certain applications to court or to enter pleas with plea statements or to enter any of the other pleas under Section 106 besides the plea of not guilty entered by the court in terms of Section 109 of the Criminal Procedure Act on their behalf? And will it not amount to a further violation of the right to a fair trial and prejudice to accused and prejudice to continue with the taking of pleas whilst accused persons have not had the opportunity to adequately consider the new disclosures and take advice from counsel on it before entering their pleas? Question number 5, is the appointment of Mr. Chinengo as an acting judge on 27 April for the period 18 September 2023 to 31 December 2023 not ultra vires the Constitution and unconstitutional as articulated in the representation of legal representation made to the Honorable Court on 4 December 2023, and whether reliance on Section 7 of the High Court Act is not misplaced on account of the Namibian Constitution, which under Article 82(4) explicitly provides for a fixed-term contract of employment for non-Namibian citizens appointed as judges. Question number 6. In the light of what Section 105 of the CPA, that is the Criminal Procedure Act, provides and what Section 7 of the High Court Act 1990 provides, and given that, Section 118 of the Criminal Procedure Act regarding non-availability of judicial officers to continue with the trial and no evidence has been adduced, when can it be said that a trial has commenced? When the availability of acting Judge Justice Chinengo has been occasioned by the lapse of employment as a judge in Namibia. 7, that is question number 7, whether the acting judge's order that the taking of pleas must proceed before him, notwithstanding that the accused persons impugn his appointment as acting judge of the High Court and also some of his decisions, falls to be set aside on the basis that the order is unconstitutional, as it violates the right of the accused under Article 12(1)(e) of the Namibian Constitution to be tried by an independent, impartial, and competent court. Now, those are the 7 questions. The reason for bringing the Section 319 application: it is not the task of this court to answer the questions sought to be reserved for the consideration of the Supreme Court. The task of this court is merely to decide whether the questions should be so reserved. Unless it is satisfied that the questions merit reservation, this court may decline to reserve the questions. The purpose of making this application is an important consideration because it casts light on the overall propriety of reserving the questions and on the issue whether the Supreme Court is with those questions. The applicants have made it abundantly clear that but for this court entering upon the taking of pleas and in the manner it did, it has been instituted. At paragraphs 62 and 63 of the founding affidavit, it is stated, and this is by the applicants, paragraph 62, in casu, if at least some of the questions I have raised are upheld by the Supreme Court, the taking of pleas must stop and the court must return to the pre-trial stage. This court was in the process of pre-trial proceedings when Mr. Acting Justice Chinengo took over the matter, and within weeks he proceeded to preside over the taking of pleas, disbelieving the accused persons and their legal representatives when they made representations, whilst believing the version of the state prosecutors who have been all along less than candid with both the court and the accused persons. 63. Given the above understanding of the Criminal Procedure Act, I felt that I was correct in law to raise the questions of law and that the position taken by the court was incorrect, requiring that the questions be determined by the Supreme Court without delay so that the criminal case can be dealt with commencing with pre-trial motions, a position the trial court refuses to entertain. It will only entertain motions, end of quote. The point at which I took over this matter is not as stated by the applicants, and in this regard, see paragraph 1 of the recusal judgment, at which the dates on which the trial had been set to commence and to continue are indicated, being the 2nd of October 2023 to 28 June 2024 to begin with. Now, understanding Section 319 of the CPA. The basic point of departure between the state and the applicants is evident from the state's opposition in this application, is whether an application for the reservation of points of law may be made before the completion of the main trial. The state's contention is that it may not, while that of the applicants is that it may. It is therefore important that an understanding of the section is clarity. Section 319, in terms of which the above questions are sought to be reserved for the consideration by the Supreme Court, provides as follows, and I quote, if any question of law arises on the trial in a superior court of any person for any offense, that court may, on its own motion or at the request either of the prosecutor or the accused, reserve that question for the consideration of the appellate division, which is the Supreme Court, and thereupon the first mentioned court shall state the question reserved and shall direct that it be specially entered in the record, and that a copy thereof be transmitted to the registrar of the Supreme Court. Subsection 2, the grounds upon which an objection to an indictment is taken shall, for purposes of this section, be deemed to be a question of law. Subsection 3, the provisions of sections 317, subsection 2, subsection 3, subsection 4, and subsection 5, and section 318, subsection 2 shall apply with necessary changes with reference to all proceedings under this section. Procedure for instituting section 19 application. The first issue to understand is how a prosecutor or an accused person may request the court to reserve a question of law under section 319 insofar as the procedure for doing so is concerned. The answer to this issue is to be found in subsection 3, which provides that the provisions of subsection 2, subsection 3, subsection 4, and 5 of section 317 and subsection 318, subsection 2, shall apply mutatis mutandis to proceedings under section 319. Read with necessary modifications, the said subsections may, without perfect drafting, be rendered thus. Subsection 2 of section 317, it will be rendered thus, that is, with the necessary modifications. Service hereunder provided an application for condonation or for the reservation of a question of law shall be made to the judge who presided at the trial, or if he is not available, or if in the case of a conviction before a circuit court, the said court is not sitting, to any other judge of the provincial or local division of which that judge was a member when he so presided. Subsection 3 would read, if the accused was convicted by a special court, an application for condonation or for the reservation of a question of law shall be made to that court, or if that court is not sitting, to any judge who was a member of that court, or if no such judge is available, to any judge of the provincial or local division within whose area of jurisdiction the special superior court sat. Subsection 4, the terms of the reservation of the question of law shall be settled by the court who grants the application for the reservation of a question of law. Subsection 5, if the application for condonation or for the reservation of a question of law is refused, the accused may, within a period of 21 days of such refusal or within such extended period as may on good cause be allowed, by petition addressed to the Chief Justice, apply to the Supreme Court for condonation or for the question of law to be reserved to be made on the record, stating in what respect the proceedings are alleged not to be in accordance with the law, and thereupon the provisions of subsection 7, 8, subsection 9, and 10 of section 316 shall apply mutatis mutandis. Subsection 318, subsection 2, with necessary modifications, would also read thus. The registrar of the provincial or local division shall forthwith, after receiving notice of the reservation of a question of law, give notice thereof to the Attorney General, and shall transmit to the registrar of the Supreme Court a certified copy of the record, including copies of the evidence, whether oral or documentary, taken or admitted at the trial, and of the reserved question of law, provided that with the consent of the accused and the Attorney General, the registrar concerned may, instead of transmitting the whole record, transmit copies, one of which shall be certified, of such parts of the record as may be agreed upon by the Attorney General and the accused to be sufficient, in which event the Supreme Court may nevertheless call for the whole record. References in the quoted paragraphs to provincial or local division must be understood to the references to the High Court in our context. The trigger for an application to reserve a question of law is that the question must arise on the trial in a superior court, and that the court on its own motion decides to reserve that question, or the prosecutor or accused person by way of application makes a request for the question to be reserved. Section 317 is clear in its application to such a request. It provides that the request must be made by way of an application to the judge who presided at the trial. The use of the past tense in the words "the judge who presided at the trial" indicates that the application must be brought after completion of trial, a point I deal with later. In terms of the High Court rules, application means an application on notice as contemplated by Part 8. Part 8 sets out requirements in respect of such application. Rule 65, subsection sub-rule 2, provides that where relief is claimed against a person, or where it is necessary or proper to give a person notice of such application, the notice of application must be addressed to both the registrar and that person. Otherwise, the notice must be addressed to the registrar only. Rule 70, sub-rule 1, provides that interlocutory and other applications incidental to pending proceedings may be brought on notice supported by such affidavits as the case may require. Rule 72, sub-rule 1, provides specifically that an application brought ex parte on notice to the registrar, supported by an affidavit as stated in Rule 65, must be filed with the registrar and set down in motion court. Three things emerge from Section 317 and the rules to which reference has been made. The first is that a request for the reservation of a point of law to the Supreme Court is made by way of an application which accords with Section 317 and 318 as specified, and rules of the High Court generally. The second is that an application may be brought ex parte where it is not necessary or proper to give notice to any person. The third is that whether the application is brought on notice or ex parte, if it is interlocutory or incidental to pending proceedings, it may be brought on notice supported by such affidavits as the case may require. In this connection, the question may be asked whether Section 319 application is interlocutory when the section provides, as we shall see, that such an application can only be brought at the end or a conclusion of the trial. It can safely be stated that an application in terms of this section is deemed not to be interlocutory. Ex parte institution of present application. The applicants instituted the present application as an ex parte application, in terms of which, strictly speaking, they were not bound or required to serve notices or affidavits on any person. They contended that no other person had an interest in the determination whether the questions of law raised were to be reserved for the consideration of the Supreme Court. Nothing could be further from the truth. The consequence of a consideration of the questions of law by the Supreme Court, so far as the applicants are concerned, is partly to secure the result that the pleas entered in respect of counts 1 to 4 fall away and the trial starts de novo. They are of the view that the state has no interest in the reservation of the questions, touching as they do on the issue whether the plea taking proceeds or not. What the applicants disregard is the fact that the raising of questions of law in terms of Section 319 is designed to provide the accused person or the prosecutor some form of appeal to a higher court in circumstances where otherwise either of them had no such opportunity. The state would obviously have an interest in the determination of the questions reserved and would therefore be a necessary party to such an application. At the very least, the state would be a party to which it is proper to give notice. Some of the questions, for example, questions 5, 6, and 7, relating to the validity or otherwise of the presiding judge's appointment and continued sitting, require that the appointing authorities, the State President and Judicial Service Commission, be served with the application. They are a necessary party in any application in which the appointment of a judge is challenged, because it is they that appointed the judge. They are, at the very minimum, parties with an interest and in respect of whom it is only proper to give notice of the application. Without engaging in speculation, the reason why the applicants moved an ex parte application was probably to ensure that they did not meet any opposition from the appointing authority or any other quarter. Despite the ex parte approach, the applicants nonetheless served their notice of motion and affidavits upon the state and their co-accused. They did not serve them upon the appointing authorities. Despite that, in earlier proceedings, the first applicant had threatened to sue the state president over the appointment of the presiding judge. The applicants, no doubt, had a reasonable apprehension that the ex parte application could be found wanting in respect of the procedure to be adopted. This apprehension was well-founded. To cover themselves, they prayed for the condonation, for condonation if the court concluded that they had adopted the wrong procedure. In this regard, I refer to paragraph 62 of the founding affidavit, where the applicants state, should it be the determination of the court that this matter should not have been brought by way of an ex parte proceeding, then in that case the court should case manage the matter and make any determination it deems fit to ensure a fair trial to any other party it feels ought to have been a respondent herein, but ought not to remove the matter from the roll, in keeping with the jurisprudence in the case of Masule versus the Prime Minister of the Republic of Namibia and others. And also, yes, that is the case that they made reference to. My answer to the question, no, the proper approach in these proceedings was to bring an application as provided by Section 319 itself, as read with Section 317 of the CPA, the Criminal Procedure Act, with service on interested or necessary parties as the case may be, the co-accused, the state, and the appointing authority in respect of questions 5, 6, and 7. My answer to the question whether the ex parte approach to the court was correct, was the correct procedure, may also provide some guidance in similar cases in the future. From what I have stated above, I am satisfied that an application on notice to the state and appointing authority was in fact the correct procedure. That is what is provided by Section 319 as read with Section 317 of the CPA. Now the question arises, should the application be dismissed on a point of procedure? Having reached the above conclusion, I have considered whether the application should be dismissed based on the incorrect procedure adopted by the applicants. I think not. Other considerations which I deal with below serve better as a basis for disposing of this application without appearing to be slavishly bound by the rules of procedure, in respect of which the applicants referred to the case of Rally for Democracy and Progress and others versus the Electoral Commission of Namibia and others, in which a general proposition is made that rules are made for the court and not the other way around. After all, the question whether the procedure adopted was correct was argued together with the other issues that arose. I therefore proceed to deal with this application holistically. Reservation of questions of law before trial is completed. It's a heading. The state's main response to this application is contained in the answering affidavit at paragraphs 5 and 6, which read as follows, and I quote, and this is a deposition by state prosecutor, where he says, I've read the notice of motion together with the founding affidavit filed by the applicants. It is my humble submission that I do not have to deal with any of the 7 questions of law listed by the applicants is the applicants have adopted the wrong procedure. Section 319 of the Criminal Procedure Act, as amended, cannot be invoked at this stage of the trial, but only at the end of the trial. It was open for the applicants, when sanctioned by law, to appeal against any rulings of this honorable court which they were discontent with. A litigant who is dissatisfied with a ruling made by a court is at liberty to exhaust his right to appeal the matter at its end. However, his here displeasure does not inspire a ground for an application for the reservation and stating of questions of law in terms of Section 319 of the Criminal Procedure Act as amended. That's the belief of the present applicants. This belief is not based on any non-legal principles. It is my humble submission that the application stands to be dismissed, as it will only result in further delay of the trial. Paragraph 6, wherefore I pray for an order dismissing the application for request for the reservation and stating of questions of law in terms of Section 319 of the Criminal Procedure Act in its entirety. End of quote. It is self-evident that the state did not engage the application for the reservation of the questions of law and its propriety, except insofar as the timing thereof is concerned. The state further argues that it is not correct for a litigant dissatisfied with any ruling of a court to invoke Section 319 when such litigant may appeal the ruling, either with or without leave of the court of first instance, depending on the nature of the ruling. It is not unusual for a litigant to request a court that has ruled against such litigant's request or application to ask the court to give its reasons, therefore, so that the litigant may properly advise himself or herself of the best course of action, whether to appeal the ruling or not. The applicants argued that if the state's objection as contained in paragraph 5 aforesaid fails, then the state would have no leg to stand on with respect to the other issues raised. They, however, acknowledged that the answer to the state's objection might well dispose of this application. The state's contention that a Section 319 application can only be made after the main trial is completed is amplified in heads of argument and oral submissions to court. Introducing the submissions, the state said that the present application stems from a series of applications made by the applicants and some of their co-accused persons, whose main purpose was to defer the commencement of the trial, another attempt to further delay the proceedings at hand, so said the state. In addressing the main point of paragraph 5 of the answering affidavit, the state submitted that an application for the reservation of a question of law must be brought as soon as possible or within a reasonable time after the conclusion of the trial. That is, after the conviction and sentence of an accused person or after such person's acquittal. Unlike a special entry in terms of Section 317 of the Criminal Procedure Act, which may be brought during the trial proceedings, the reservation of a question of law may not be brought during a trial. In this regard, they relied on the authority of Ndala versus the state and Pinheiro and others, the state versus Pinheiro and others. The applicants do not dispute that Ndala and Pinheiro are to the effect as set out by the state. They contended that there is more enlightened jurisprudence from South Africa, which this court must find more persuasive and depart from the two decisions of the High Court of Namibia. I must observe that while its decisions of the South African courts, as with decisions of any other jurisdiction, have persuasive value, those courts are not, and I quote, of higher status than the High Court of Namibia, so as to say applicants, as applicants imply, they are of decisive or of superior authority. In support of their contention, the applicants refer to Ara versus Adams and others, Ara versus Mene, both of which were considered in S versus Basson and S versus Bookhoud. The applicants submitted that the last two cases, Basson and Bookhoud, are to the effect that a Section 319 application can be brought at any time before the trial is completed. They implored me to be persuaded by their interpretation of Basson and Bookhoud and espouse it in this application. They submitted that Ndala and Pinheiro, and I quote, are quite distinct and need not be regarded by this court, and further that this court, and I quote, is not bound by the horizontal precedent of this court, which is not only antiquated but also wrong and deserves to be disregarded. They attempted to distinguish the two cases from the present one, but apart from doing so in relation to the facts, I cannot fathom any distinction in relation to the ratio decidendi of the two cases. They conclude that by stating that Bookhoud put this matter to rest in South Africa, where in at paragraph 31 to 33, the Supreme Court of Appeal held that there was no bar to the questions of law to be raised, particularly when them being raised can effectively bring proceedings to an end. The valiant effort to persuade me to follow Basson and Bookhoud is informed by the applicant's understanding that the position in South Africa before and after the democratic constitution is different. In this regard, the applicants reiterate the obvious point that the legislation that existed before the independence constitution of Namibia, just as in South Africa, must be construed in accordance with the new constitutional dispensation. To fortify this argument, they refer to Basson, the Supreme Court judgment at paragraph 115, where the court said the following, and I quote, "One of the consequences of the advent of our constitutional democracy is the requirement that all laws must be construed in the light of the Constitution. This requirement flows from the supremacy of the Constitution. It is thus axiomatic that, where possible, legislation must be construed in a manner that will bring it within the constitutional bounds. Thus, when legislation is capable of more than one possible construction, the one that brings the legislation within the Constitution ought to be preferred. As this court observed in Daniels versus Daniels NO and others, when dealing with the old order legislation, this interpretative injunction may require courts to depart from a construction previously placed on the legislation. It is to be noted that both Basson and Bookhoud were decided in 2007 and 2011, before Ndala was decided in 2013. They were not considered in Ndala or referred to therein either because counsel who argued the matter did not think that they were relevant, or because they were not aware of the relevance to the issues before the court. It is more likely the former. Eminent and diligent counsel represented the parties, and it could not have been lost to them that decisions that departed from the established understanding of Section 319 in South Africa, as present applicants contend, had been handed down in the highest courts of South Africa. The non-reference to these cases in Ndala does not, however, absolve me from having to examine the validity of applicants' submissions that a Section 319 application can be brought before the criminal trial from which it purportedly arises has been completed. The High Court, Judge Wolf, as he then was, conclusively determined the issue with which I am now seized. He said the following, and I quote, at paragraph 21, however, counsel and those accused persons represented by her are faced at this stage with another insurmountable hurdle, that being that the points of law intended to be raised would be raised prematurely. In Ara versus Ngema, Ara versus Ncele, the following appears. The history of Section 366 was examined by this court in Ara versus Solomons and in Ara versus Adams, and no good purpose would be served by now repeating the examination or by reproducing the reasoning reflected in the judgment of the latter of those two cases. It suffices that Section 316, which is the old section, is the same as 319, in its present form was authoritatively interpreted in Ara versus Adams, and that in accordance with that interpretation, a conviction is a condition precedent to the court's entertaining questions of law reserved, at the instance of the accused, for the consideration pursuant to the provisions of that section. It thus becomes necessary to determine whether or not the present appellants can rightly be said to be convicted in the court of law. At paragraph 23, Judge Wolf continues, the provisions of Section 319 are to a large extent couched in language similar to the provisions of Section 366 of Act 56 of 1955. At paragraph 24, a point of law in terms of Section 319 subsection 1 may therefore be raised only at the end or at the conclusion of a trial, not in contradistinction to a special entry in terms of Section 317 during the trial or within a period of 14 days after the conviction or within such extended period as may upon application and on good cause shown be allowed. 28. It's my paragraph 28. The learned judge referred with approval to cases that followed Ara versus Ngema and concluded it should by now be crystal clear to everyone that the prayer by counsel to be allowed to raise these points of law before proceeding with the trial can by no means be entertained by this court and should accordingly be refused. Pinheiro was decided before Ndala and is to the same effect. In Pinheiro, a mortgage holder applied to the court for fishing vessels used in the commission of an offense not to be forfeited to the state. The application was made after the accused persons concerned were convicted, but before they were sentenced. The court found nothing wrong with the question, with the application at that stage of the proceedings. It reasoned that the intervention of the mortgage holder before sentence was passed was proper because the proposed forfeiture order did not deal specifically with conviction or acquittal. It refused to a request by the state to reserve a question of law for consideration by the Supreme Court arising from the court's decision favorable to the mortgage holder because it determined that Section 319 was not applicable. At page 290, Stridom JP had this to say. What is clear is that the question of law must arise on the trial of any person for any offense in a superior court. In my opinion, the trial referred to in the section, in the case of a conviction, is the prosecution of the accused for an offense allegedly committed by that accused, the defense set up by such accused in order to avoid such conviction, and any sentence imposed following a successful prosecution. By no stretch of the imagination can it, in my opinion, be said that the questions arising from an inquiry in terms of Section 17 of Act 58 of 1973, that is an inquiry into the propriety of a forfeiture order, arose on the trial of any person for any offense. The applicants relied largely on Basson, the constitutional decision, and Buckhout for their main submission that Section 319 application can be brought before the completion of the trial. They were emboldened by these cases to state, and I quote, the interpretation that Section 319 can only be invoked after an acquittal or a conviction no longer holds sway in South Africa post the Basson judgment, and it is a position commendable to the High Court of Namibia. In S versus Beckhout, the matter is put to rest in South Africa, again, as I earlier quoted, at paragraphs 31 to 33, where the Supreme Court of Appeal of South Africa held that there was no bar to questions to be raised, particularly when them being raised can effectively bring proceedings to an end. I have had occasion to read and consider the decisions in the two cases relied upon by the applicants. It seems to me that the applicants did not fully appreciate the context in which Basson and Beckhout can be said to open the door for the reservation of questions of law before the conclusion of a trial or before the accused are convicted and sentenced or acquitted. In both cases, the courts were called upon to consider the reservation of questions of law arising from the holding of an exception to a charge, or to put it another way, the quashing of a charge or charges upon application of the accused person. The statements by the Constitutional Court and the Supreme Court of South Africa must therefore be viewed and understood in that context and from that perspective. They were confined to the facts before the court, by the facts before the court, to a situation where the court had to consider Section 319 against the background of a successful exception to a charge or the quashing of a charge. That is why in Beckhout, the court had the following to say, and I quote, paragraph 31. Before the judgment of the Constitutional Court in S versus Basson, the constitutional decision, this court had repeatedly held that a question of law could only be reserved in terms of Section 319 of the Criminal Procedure Act upon conviction or acquittal of an accused, and that in order upholding an exception to a charge was neither a conviction nor an acquittal, and consequently could not be reserved for consideration by this court. In Basson, the Constitutional Court was concerned with circumstances where the upholding of an objection to an indictment had the effect of barring the state from prosecuting the accused on charges which were quashed. Paragraph 32, the Constitutional Court had regard to the state's prosecutorial authority, enabling it to fulfill its constitutional obligations to prosecute those offenses that threaten or infringe the rights of its citizens. It noted that the purpose of Section 319 was, amongst others, to allow the state to appeal on a point of law to the Supreme Court of Appeal. At paragraph 148, the following is stated, that is in Basson, the constitutional case. Section 319 provides that if any question of law arises on the trial in a superior court, the court may, on its own motion or at the request of the prosecutor or accused, reserve the question for the consideration of the Supreme Court of Appeal. There is nothing in the language to suggest that the state may only request the reservation of questions directed at the conviction or acquittal of the accused. Section 319, subsection 2, indeed strongly suggests that the legislature intended to permit an appeal against any order upholding or dismissing an objection by way of a reservation of a question of law. The subsection provides that the grounds upon which any objection to an indictment is taken shall, for the purposes of Section 319, be deemed to be a question of law. At paragraph 33. Whilst appreciating that there was a well-established legislative and judicial policy which precluded piecemeal appeals to the Supreme Court of Appeal, the Constitutional Court noted that there was no such problem where the only charge against an accused is quashed. That effectively brings the proceedings to an end. The same would apply in the event that all the charges in an indictment were to fall away because of a ruling on jurisdiction. It went on to hold that there is no bar to a question being reserved in this regard. In Basel, which informed Buchhout, the Constitutional Court considered the proper construction of Section 319 having regard to its legislative history and the context of the democratic constitution of South Africa. At paragraphs 147 to 152, it had this to say. I will quote this extensively because this is the case on which the applicants nailed their mark. At paragraph 147, the amendments introduced by the 1948 Criminal Procedure Amendment Act were no doubt intended to address the legal position that prevailed prior to the amendment. That position was that the prosecutor could at no stage request the reservation of any question of law at all on behalf of the state. The amendment altered this position by allowing the prosecutor to request the reservation of a question of law on behalf of the state. This legislative history of Section 319 makes it clear that it was intended to afford the state the right to appeal a question of law to the Supreme Court of Appeal. This right is incidental to the right of the state to institute criminal proceedings provided in Section 179, subsection 2 of the Constitution. But was it intended that this right is available only in limited circumstances? 148. There are indications both in the language of Section 319 There are indications both in the language of Section 319, subsection 1, and in the context in which that section occurs that it was not the case. Section 319, subsection 1 provides that if any question of law arises on the trial in a superior court, the court may, on its own motion or at the request of the prosecutor or the accused, reserve that question for the consideration of the Supreme Court of Appeal. There is nothing in this language to suggest that the state may only request the reservation of questions directed to the conviction or acquittal of the accused. Section 319, subsection 2, indeed strongly suggests that the legislature intended to permit an appeal against any order upholding or dismissing an objection by way of a reservation of a question of law. The subsection provides that the grounds upon which any objection to an indictment is taken shall, for purposes of that section, be deemed to be a question of law. In holding that a question of law can only be reserved at the conclusion of the trial, the court in Adams relied, among other factors, upon the long-established legislative and judicial policy which precluded piecemeal appeals to the appellate division. The problem with midstream appeals does not arise where the only charge against the accused is quashed by the High Court. The quashing of such a charge brings the proceedings to an end. Yet the Adams rule maintains that there is no right of appeal in such situations because an order upholding an exception is neither an acquittal nor a conviction. Even those cases where there are multiple charges, the quashed charge or charges may have no relation to the remaining charges. In such a case, there is no reason why the trial should not proceed in relation to the remaining charges while the question of law arising from the quashing of the charges is taken on appeal. Where the exception is dismissed, fairness may require that the accused not be subjected to a full-blown trial where in fact the exception is well-founded. The effect of Adams' rule is to take away the right of the state to appeal against an order of the High Court upholding an objection that a charge does not disclose an offense in law. The court suggests that if an objection to an indictment is upheld, the state can amend the indictment or present a new one. But this does not overcome the situation where, as here, the order upholding the objection has the effect of barring the state from prosecuting the accused on the charges which were quashed. The effect of the Adams rule is not only to prevent the state from instituting criminal proceedings where a court quashes an indictment on the ground that it does not disclose an offense, but it also takes away the right of the state to appeal against a decision upholding an exception to his indictment for another reason. Such an interpretation of Section 319 is inconsistent with the right of the state to institute criminal proceedings and thus with the Constitution. In addition, such an interpretation is inconsistent with both the purpose of and the language of Section 319, namely to allow the state to appeal a question of law arising from an order upholding an exception to an indictment. We agree with the observation made by the court in Mene, in which the court below stated that Section 319 is capable of another construction. In our view, so the Constitutional Court says, Section 319 should not be construed so as to prevent an appeal against an order dismissing or upholding an exception. The section should be construed so as to allow the state or the accused to appeal against an order upholding or dismissing an exception. Such a construction of Section 319 brings it within constitutional bounds by recognizing the right of the state to institute criminal proceedings and, if need be, to appeal an adverse finding on a question of law. It is this construction of 319 which must be adopted. It follows, therefore, that Section 319 did not prevent the Supreme Court of Appeal from considering an appeal against the order of the High Court quashing the charges relating to conspiracy. The Supreme Court of Appeal therefore erred in concluding that Adams' rule constituted a bar to the reservation of a question of law relating to the quashing of the charges. Now I continue. It must be noted that in Basson and Beckhout, the issue of reservation of questions for the consideration of the Supreme Court of Appeal was brought after the completion of the trial. That is, the acquittal or conviction of the accused, and related to a situation where an exception to the charge had been successfully taken midstream, and there had been no request for questions of law arising therefrom to be reserved before the conclusion of the trial. That is not the situation here. The application here was made during the plea stage, after the accused had been called upon to plead to 4 counts out of many and not guilty pleas entered for them. The question thus arises whether at that stage of the criminal trial, questions of law arising in connection therewith can or ought to be reserved for consideration by the Supreme Court. I probably would have been inclined to adopt the approach in Basson and Beckhout if this application was instituted by the state following upon the quashing of any of the charges in the criminal trial. I would most likely have espoused the reasoning that the quashing of any of the charges, depending on what other step or steps the state took, had brought the trial on those charges to an end, and there should be no bar to reserving questions of law under Section 319. An objection to an indictment, as stated in subsection 2, is deemed to be a question of law for the purposes of that section. The questions sought to be reserved in this application is self-evident, are not questions arising from the quashing of any charges. They are questions which, following the law as enunciated in Pinheiro and Ndala, should be raised after conviction and sentence of the acquitter or the acquittal of the accused persons. To reserve them for consideration by the Supreme Court at this stage of the criminal proceedings would be to open the doors wide for piecemeal appeals during criminal proceedings. To be noted also is that Basson and Beckhout did not lay down as a general and inflexible rule of law that all applications in terms of Section 319 may be made at any time, even during trial. A benevolent interpretation of the two cases is that, depending on the facts of the case, some Section 319 applications, such as an application following upon the quashing of a charge, may be so brought. On the facts of the application before me, the law is set out in the Namibian cases is sound and must be followed. I am not persuaded that there is any basis for departing from those decisions. The proper understanding and application of Section 319 in the context of this application is that the questions of law raised may be reserved only after the trial has been completed. For these reasons alone, the whole application stands to be dismissed. Other requirements for reservation of points of law. In seeking to further understand Section 319 in its other respects, I must, as a judge of first instance, consider the other requirements for invoking that section, principally because they were canvassed during the hearing. Those requirements are set out clearly in the Namibian cases and South African cases referred to above and succinctly summarized in S versus Bassos, the Supreme Court of Appeal case, where the court stated that the state, and I quote, the state has no right to appeal in terms of the act against incorrect factual findings by a trial court. The state can appeal only if the trial court gave a wrong decision due to a mistake of law. In order to determine whether the trial court erred in law, the factual basis upon which it based its decision must be determined. Another factual basis cannot give an indication whether the court made a mistake of law. It follows that a question of law arises when the facts upon which the trial court based its judgment could have another legal consequence than that which the court, the trial court had found. For those reasons, for those reasons, A, there must be certainty regarding the legal issue being raised and the facts upon which the trial judge based her or his findings. And B, when a question of law is reserved, it has to be set out clearly not only which legal issue is raised, but also the facts on which the trial court based its finding. It is emphasized in all the cases that there must be certainty regarding all the facts to which the question relates or on which the legal point hinges. Another requirement is that the questions of law must arise on the trial of a person for any offense. The phrase "on the trial" has been judicially interpreted as connoting that the trial has been completed and that the application can only be brought after conviction and sentence or acquittal. In my opinion, the interpretation of "on the trial" also encompasses the grounding of the question on the conduct of the judge in hearing the case and not on extraneous factors such as the validity or otherwise of the judge's appointment, which issue can be raised separately either as a recusal application or more appropriately in this case as a plea to jurisdiction of the court, basing such plea on the court's competence. Yet another requirement which in my view arises from the present application is that the question to be reserved for consideration by the Supreme Court must not be one that the court has considered and disposed of one way or another, so as designedly to afford the applicants a second bite at the cherry. I, however, do not address these other requirements in detail because of the conclusion I've reached that this application can only be properly instituted after the trial has been completed. I am alive to the fact that the state's written submissions, brief as they are or were, and based on paragraph 5 of the answering affidavit, did not directly or in detail deal with these other requirements of Section 319. I, however, canvassed those requirements with the parties at the hearing. Additionally, I put it to the applicants that the mere fact that the state did not deal in detail or at all with these other requirements did not mean that the applicants would ipso facto succeed on them. The court still had to apply its mind and decide them as necessary. The applicant's representative agreed that this would be the correct approach. I now deal with these other questions under two main heads: whether all the questions sought to be reserved arise on the trial in the second sense I have enumerated above, and B, the impact of this court's decisions on recusal of the presiding judge Second point is the impact of this court's decisions on recusal of this presiding judge on questions thought to be reserved, having regard to the clarity of facts on the points on which the points raised are hinged. Do all the questions arise from the trial? Question 1, 2, and 3, and 4, no doubt arise from the trial in the sense that their genesis is what is alleged to have happened in the course of proceedings to date. They are concerned with whether a judge faced with a recusal application may refuse to take any further action ancillary to the criminal case in which the judge is asked to recuse himself pending his decision on the recusal application, or an application to him for leave to appeal the recusal decision, or pending the determination of a petition to the Chief Justice on his refusal to grant leave to appeal the recusal decision. And secondly, whether a judge faced with a request under Section 319 may defer, hold in abeyance, or refuse to consider such request when it is made, and whether a lack of legal representation of the applicants or their continued prosecution before the issue of lack of legal representation is resolved does not violate, infringe, impair, or negate the accused person's right to a fair trial, whether the taking of pleas in December 2023 before the state disclosed certain material, some 30 files on 15 February 2024, does not amount to a violation of the applicant's fair trial rights, where the disclosure could possibly have provided a basis for challenges to the charges or resulted in a tender of any other plea as provided under Section 106 of the Criminal Procedure Act, and finally, whether the continued taking of pleas would not amount to the same violation. As earlier stated, questions 1 and 4 arise from the trial and could be reserved absent any other reason for not reserving them, such as that they were prematurely raised, as I have found. The same cannot be said for questions 5, 6, and 7. These are concerned with the validity of the appointment of the presiding judge. Question 5 is whether the appointment of the judge for the period 18 September to 31 December is not ultra-virus and unconstitutional, and whether reliance on Section 7 of the High Court Act is not misplaced regard being had to Article 82, subsection 4 of the Constitution. Question 6 is difficult to paraphrase. I simply repeat it as follows. In the light of what Section 105 of the CPA provides and what Section 7 of the High Court Act provides, and given that Section 118 of the CPA regarding the non-availability of the judicial officer to continue with the trial and no evidence has been adduced, when can it be said that a trial is commenced? When the unavailability of acting Justice Chinengo has been occasioned by the lapse of his fixed-term contract of employment as a judge of Namibia. Broadly speaking, question 6 is related to the presiding judge's appointment and predicated on the factual supposition that the judge's tenure has lapsed. Question 7 is whether the order that plea taking must continue before him is not unconstitutional as a violation of accused person's rights to be tried by an independent, impartial, and competent court when the accused persons impugn the constitutionality of the judge's appointment as acting judge of the High Court and also some of his decisions. There can be no doubt that the last 3 questions, being questions 5, 6, and 7, revolve around or implicate the appointment of the presiding judge. The question therefore arises whether the appointment of the presiding judge is a matter that arises from his conduct of the hearing. This is a question that touches on the jurisdiction of the court. It begs the question whether the judge is competent to hear or deal with a criminal trial at all. That being so, the question should have been raised initio litis, that is at the beginning. This is particularly so in respect of question 5. Conceivably, it could have been brought as another basis for the judge's recusal and heard together with the recusal application in Van Wyk versus the state. Assuming the challenge to the validity of the judge's appointment as merit, It is such a challenge as at this stage requires that the application be brought by way of notice of motion and served upon the appointing authorities and other interested parties, which has not been done as shown by the ex parte approach adopted by the applicants. There is yet another reason for taking a dim view of the reservation of questions 5, 6, and 7. It is that the facts on which the questions may be hinged are not entirely clear. The Supreme Court would, upon reservation of the questions, have to have the facts established before it. The applicants argued that the facts are clear in that the relevant government gazettes provide the necessary clear facts. I do not think so. In my view, only an application on motion will set out all the facts upon which the point of law arises. If it is anyone's guess whether the appointing authority would not contest any of them, the idea behind Section 319 is that the facts on which the question is hinged must be clear or uncontested, thereby enabling the Supreme Court to answer only the question of law presented to it. For these reasons, I would decline reserving the questions 5, 6, and 7 for consideration by the Supreme Court. Impact of the recusal decision. Questions 1 and 4 arose in the recusal application, Van Wyk versus the state. The recusal application was filed by only one of the accused persons, the others not formally associating themselves with it, despite in the case of accused 4, having intimated that he was going to apply for my recusal, and accused 3, the lead applicant herein, also making it known he would challenge my appointment and would institute a Section 319 application, alternatively sue the state president in regard thereto. With the benefit of hindsight, it appears to me that although the present applicants were as much aggrieved by the conduct of the trial, particularly the requirement that the accused be required to plead to the charges, they either deliberately or calculatedly shied away from directly engaging with the recusal application. They must have calculated that if they made common cause with the applicant in Van Wyk versus the state, they would deprive themselves of a duplicative opportunity to raise the same or similar questions and cause further delay until the issue of their legal representation was resolved. The present applicants have done exactly that, in my view. During the hearing, I specifically called upon the parties to state whether, in their opinion, any of the questions raised in terms of Section 319 had been dealt with or addressed in the recusal application, and the application for leave to appeal the recusal decision, and directly or indirectly considered by the Supreme Court in the petition. I did so in order to highlight, as I do anon, that any issue dealt with in the two judgments, the main recusal judgment and the leave judgment, should not be placed before the Supreme Court again. It cannot be the right approach to litigation that the same questions are placed before the Supreme Court. That would be a waste of scarce resources and clearly an abuse of court process. Question 1 begs an answer to the question whether a judge against whom a recusal application has been made and or is seized with an application for leave to appeal against the refusal, against his refusal to recuse, or while a petition to the Chief Justice on his ruling on the leave application may decline to deal with any issues that arise from or are connected with the trial and restrict himself only to managing the case in the most menial manner. That is the position that I took and justified in the recusal decisions. Without at all endeavoring to answer question number 1, the law as long understood should have guided the applicants in S versus Lagrange and others, referred to with approval in MMV versus Khan and others. It is that the disqualification of a judge who should have recused himself or herself is so complete that continuing to preside after recusal should have occurred renders any further proceedings a nullity. Why would a prudent judge not be guided by this legal position? The petition was dismissed by the Supreme Court, thereby impliedly, if not directly, affirming the stance I had taken. Question 2 is whether I could decline to entertain Section 319 application until I completed, as I had decided, the taking of pleas. This question is rather academic in the sense that the applicants did not state as a matter of fact that they made that application and I declined to deal with it. What is recorded in the recusal judgment is that the first applicant initially handed over a notice not issued by the registrar during a hearing, and later during the recusal hearing, he again indicated that he would bring an application, such application. He has now done so. If no application like the one before me was brought for my consideration, then the question is academic. Apart from the decision I have come to that a Section 319 application may only be made at the end of the trial, the facts on which the application is based are not clear to satisfy one of the requirements for the reservation of a question of law. Question 3 is about whether proceeding with the trial in fine taking pleas when accused persons, in this case the applicants, are without legal representation is not a violation of the right to a fair trial as provided by Article 12 of the Constitution. The issue was canvassed and addressed extensively in the recusal judgments, not only in relation to the applicant concerned, but also his co-accused, including the applicants. There is no need to repeat what I said in that judgment as a reading of it. Suffices to show how extensively the issue was addressed. When the Supreme Court dismissed the petition in the recusal matter, it obviously considered the applicant's representations on the issue and the decision I had made therein. My decision was accordingly affirmed, and it would be putting the same question to the court if this question was reserved. Question 4 is whether the continued taking of accused persons' pleas to the charge they are facing after the disclosure by the state of 30 files on 15 February 2024 does not constitute a violation of the accused's fair trial rights. The contention here is that the accused refused to plead to 4 counts in December and not guilty pleas were entered for them. The state then disclosed the said files in February 2024, which means that if the plea taking continues before the applicants have had the opportunity to consider the contents of those files and determine for themselves what approach to take to the charges, their right to a fair trial will be violated. The state explained that the disclosure of the 30 files was at the sole instance of the accused. The state had and still has no intention to use any material in those files because the files are irrelevant to the prosecution of the offenses faced by the accused. When the accused requested for those files, the state handed them over for whatever they were worth to the accused and to show that the state did not intend on hiding anything from the accused. Otherwise, the contents thereof are not material to the prosecution case. The applicants believe that there might be something in the 30 files that will enable them to consider their approach to the charges. They have had those files now for just over 6 months, and they have not, so far as the court is aware, then done anything about them, nor have they given an indication at the hearing of what they make of them. This application, so far as question 4 is concerned, is, in my view, a disguised way of interdicting the court from continuing with plea taking, which the applicants anticipate will be embarked upon now that the recusal application has been disposed of. The facts as to why the disclosure was made and for what purpose are not common cause between the parties. As I have said, on the part of the state, as already indicated, the disclosure was made simply because the accused requested for the files and the state obliged for purposes of transparency. Finally, the court's decision to take pleas was examined in the recusal decision, and the Supreme Court affirmed that decision by dismissing the petition. Regarding questions 1 to 4, a reading of the recusal judgments would show that the issue of the fair trial rights of the accused, including the applicants, was dealt with in the context of the decision to take pleas from them. At paragraph 28 and 29 of the main recusal judgment, the issue is discussed. Starting at paragraph 59 of the judgment, I dealt with the issue of legal representation and pointed out at paragraph 60 that this was the main stumbling block to the trial. I even expressed sympathy for the accused in this connection at paragraphs 28 and 29, and in essence invited accused persons to approach this court for relief as may be appropriate. When the Supreme Court considered the petition placed before it in the recusal matter, it read the recusal judgments and dismissed the petition. If the same questions are placed before it, albeit in a different application and by different applicants, nothing more than a repetitive litigation would have been embarked upon. I venture to say that in a trial involving several accused persons, such as the criminal trial herein, it is not a good strategy for the accused persons not to identify themselves with an issue or objection raised by one of them in the hope that they can bring a similar issue later and thereby cause delay to the criminal proceedings and meet their purpose. That properly viewed amounts to an abuse of the court process, causing delay to the criminal trial. Arising from the state's assertion at paragraph 5 of the answering affidavit that this application will only result in further delay of the trial, much time was devoted at the hearing to debate which of the parties, the state or the accused persons, are causing delay to the criminal trial. In my view, that debate was entirely unnecessary. Each party is entitled to take up a point as it sees fit, provided that it is not abusive of court process, whether or not a delay will be occasioned. In this case, an unsuccessful midstream application by its nature causes delay to the main trial, but that is in the nature of criminal proceedings. I am not willing to be drawn into the debate and determine who of the parties is causing any delay to the criminal proceedings at this stage. An answer to this question does not assist in any meaningful way. Points in limine raised by the applicants in heads of argument. In their heads of argument, the applicants raised 2 points in limine, which are in effect 1 point. They contended that the notice of opposition and answering affidavit filed for the state was not authorized, or there is no evidence that the persons who signed those documents were duly authorized thereto by the Prosecutor General. It turned out that the notice of opposition and the heads of argument were signed by Mr. Marondeze and the answering affidavit by Mr. Lutuvezi. Both these officers are the prosecutors in the main criminal trial. The applicants concede that they are. The applicants, however, argued that the fact that they are authorized to prosecute the criminal trial does not mean that they are also authorized to oppose or deal with the present application. I do not find any force in the applicant's argument. It stands to reason, and without need for citing authority for the proposition, that as prosecutors in the criminal trial, they are entitled to deal with any application that is filed in connection with that criminal trial. It is true that if their authority is challenged, they have in a proper case to produce the authority to do so. This, in my view, is not such a proper case. Mr. Lutuvezi, as is common cause, is authorized to prosecute the criminal trial. He does so, as stated by the applicants, under the control and direction of the Prosecutor General. If there was anything amiss about the representation, the Prosecutor General would no doubt exercise a power and bring an end to any unauthorized representation in an important public prosecution such as this. The applicants did not contest Mr. Marondeze's entitlement to argue the application, and yet he is in the same position as Mr. Lutuvezi. There must be a sound basis for contending that the two prosecutors are not authorized to represent the Prosecutor General in this application. I was not convinced that there is any such sound basis. The points in limine stood to be dismissed. Disposition. I have considered the submissions made to me in this application. The main conclusion is that a Section 319 application such as this may only be instituted after the completion of the trial. Other findings made in fairness to the extensive argument on them by the applicants are that questions 1 to 4 have been addressed in the recusal judgments and should not be placed before the Supreme Court again. Questions 5 to 7 are concerned with the competence of the court to deal with a criminal trial and should have been the subject of a separate application, either as a challenge to the court's jurisdiction or as a standalone application served on the appointing authority. I also opined that this application is a disguised form for seeking an interdict against continuation by this court to take place from the accused person, an exercise that has started and has been stalled by the application, by this application and the previous recusal application. The result is that this application must be dismissed. The issue of costs does not arise. My order is that it reads, it is ordered that the application be and is hereby dismissed with no orders of costs.
It's a court, please.
That is my judgment. I'm looking for my pen.
My Lord, maybe the next issue is for the further directions as to how the matter must proceed from now onwards.
Can I just get a pen from the register? That's a pen.
My Lord, the next thing is to decide the next the direction which this matter should proceed. Maybe before I make any suggestions, my Lord, maybe we need to hear from the applicants what do they need to do with now that this application has been dismissed. Do they want to take the matter further, or they don't want to take the matter further? Then we can decide what to do, my Lord. But I think without preempting what they are going to say, maybe I should hear what they're going to say, then the state will make suggestions what it proposes should be done, my Lord.
How long as applicants, in terms of the rules, how long do they have to file an appeal? How long do they have?
My Lord, they have 14 days in terms of section 316. And 14 days is 14 calendar days, my Lord, including Saturday and Sunday.
Yeah, I think I had in mind giving them some time, giving the applicants some time to go through the judgment and decide what they will do about it. If they will petition the Chief Justice, well and fine. If they do not, well and fine. But I didn't intend to give them too long a time, because in any event they must file, you say 14 days, if you are correct, within 14 working days, they must file their petition, isn't it?
No, application for leave to appeal.
application for leave to appeal,
Yes.
or whichever it is. But they've at 14-day period, isn't it?
That's correct, my lord.
Yeah, but I would want them to indicate latest by Tuesday what their position to the decision is, and then we take the matter up from there. Another point which I understand, Mr. James Atikulipi, you made an application. I understand you made an application under POCA, isn't it? And that the judgment is likely to be handed down tomorrow.
Yes, Judge, correct.
Yes. I also think that in respect of legal representation, assuming you succeed as Mr. Esau did,
Yes, Judge.
that would cover you and who else?
Myself and Pius, I think it's accused 5. 6.
Matelulo.
Waterloo, yes.
So that application pertains to the two of you.
No, what I have considered is that in the interest to try and speed up the trial, I would not mind to assist him.
Oh, so if you are successful in that regard, that means the two of you are covered in respect of funds for legal representation.
Yes.
That would leave who now? Is it, how many would be left without legal representation?
I can speak for myself. I am aware that Mr. Gustavo is self-representing as well, although he's not here. And I think that would be it.
Yeah, Mr. Gustavo has already indicated that he will represent himself, isn't it? The only person, it seems, would be you. Have you filed an application under POCA?
No, I haven't. You see, Judge, I'm becoming very wary to be open and frank to you because we don't have a record to always reflect on, and you may misunderstand me, it seems.
No, don't worry. If you don't want to be open, it's entirely up to you.
Because
It's entirely up to you.
no, well, look, Judge, let me just record that.
No, anyway, let me amplify on the point I wanted to make.
Yes.
I was simply making the observation that if Mr. James Atikulipi succeeds in his application in the same way as Mr. Esau did, isn't it? That would mean there is only one person who has no legal representation, because we know Mr. Gustavo has said he will represent himself, right? And as you can see, we have many legal practitioners here representing the parties, isn't it? Everyone needs to plan. Everyone needs to know how we are moving, and that is why I wanted to give the opportunity to the lawyers to consult each other and advise on the best way forward. Because I know that from those who are in legal practice, if a case is not scheduled, it's disruptive of everyone's program. And so we need to be satisfied that when we proceed, we'll proceed with everyone available.
That is fine and well, Judge, but I think we're putting the cart before the horse. And while I'm not abandoning the issue I wanted to raise, I'm parking it. I'll deal with it later, perhaps not even today, but I will deal with it because I'd like it recorded. I think in the instance where you have dismissed my application, I thought that the judge would want to engage me to inquire whether or not I intend to.
I've said I'm giving you up to Tuesday.
Well, you see,
thereabouts.
you see, Judge, Again, you have taken a decision without me.
No,
even-
I'm consulting you. I'm saying that is my inclination.
The word you used was you have, and you proceeded.
It doesn't matter, but that is my proper
No, no,
intention.
no, no.
My
Judge-
proper intention is that I give you some time to reflect on the judgment, make your decision whether you take it up or not.
I appreciate that. But Judge, you see, the Supreme Court has recently, in the Kennedy case, indicated that words have a meaning. And the continuous use of words give me a meaning coming out of what you are saying. I'm not telepathic, you are not telepathic, so I can only understand what you verbalize. So the first issue I wanted to raise, Judge, is my concern that when certain nomenclature starts making their way into your judgments, I become worried. You used the word Fishrot, coined by the book that I used here. I showed you a book. They're the ones who coined this term Fishrot. This case has a name. It's the state versus
Shanghala.
Gustavo.
Mr. Shanghala,
Yes.
look, you are very free to take up everything with the Supreme Court. You
Yes.
see, there's no point after I've written my judgment, you speak about it to me. I've made my decision, and I stand by it. And if you are unhappy with it, you know what to do.
In other words, Judge, you are saying you will continue using the terminology Fishrot.
Well, I'm not the one, you are the one who brought a book called Fishrot here.
But you said this case is Fishrot. I applied in case S v Gustavo 06-2021. All I'm asking for is, and I'm making the point, that words have meanings. This is what the Supreme Court has said. But in any event, let me address the issue. Court orderly, I'd like to take issue with what Mr. Marondeze had said. They indicated dias, the days for the judge, for the prosecution, and for those three lawyers there. The days indicated in the rules, Judge, are court days. Court days are not the same as the days in the interpretation of law's proclamation.
What is that? Just, hello?
What I'm giving you now
Yes?
is an application in terms of Rule 32 of the Rules of the High Court for direction. And that's the second issue I want to deal with.
Okay.
You've indicated that if I want to appeal, I have until Tuesday to indicate. But I don't know what to indicate because I'm seeking directions in terms of Rule 32, whether or not I'm required to make an application for leave to appeal or whether the appeal and the petition, which is called a petition, is as of right. And I have looked at the rules because you've chastised me on the issue of how I came here. I'm trying to be very careful. So I'm entitled to make an application for directions in terms of Rule 32 of the Rules of the High Court. And I have now given notice. The Rule 32 application for directions must be given at least 4 days notice. I'm giving the notice, I've served it upon you. In terms of Rule 8, I will go and serve it now and file it in the registrar's office. I hope that will not be interpreted as a tactic to delay. I want to record because I'm trying to follow the rules. It seems when one raises one's rights under the legislation, one is delaying the trial, as if we must just keep quiet and just go ahead.
I think in my judgment, I've said it's your right, even if the delay is caused.
So the notice, Judge, is that on a date that you determine, I would like to hear to be heard.
Yeah, I'll deal with the notice when it is issued, Mr.
Excuse me, Judge?
I'll deal with the notice when it is properly issued.
Sorry?
I will deal with your application when it is properly issued.
No, in terms of the rules, This application does not require an affidavit unless you so direct. In fact, let me just indicate to you what Rule 32 says. Rule 32 of the Rules of the High Court of 2014. In any cause or matter, any party may make application for directions in respect of an interlocutory matter on which a decision may be required, either by notice on a managing judge's motion court day or at a case management conference, status hearing, or pre-trial conference. The party making an application under sub-rule 4 must give not less than 4 days' notice of the application to the other party or parties. The party applying for directions must, in his or her notice, set out the issues in respect of which he or she intends to ask directions, and the issues may include generally the proceedings to be taken in the costs and the costs of the application. Despite sub-rule 6, specific directions must be sought on the proposed dates for the exchange of further pleadings insofar as intervening circumstances, and that one is not necessary. No affidavit may be used in the hearing of an application for directions except by leave of the managing judge, and the managing judge must give an order extempore on the direction sought, and in any event not more than 3 days after the hearing. So that is the reason why the notice has been given. I have stated the issues in the notice, and I would request that a date be issued when I can be given those directions. The filing is it being served in terms of first serve the litigants and then it's filed in the registrar's office in terms of the rules. As it pleases the court.
Yes, Mr. Mohammed.
My Lord, firstly, the state was not wrong when it indicated about the days which the applicant has to file application for leave, because the application for leave to the Supreme Court is provided for and should be done in terms of Section 316 of the Criminal Procedure Act.
What?
316, subsection 1. And it's 14 days in terms of the Act, and the days in terms of the Act are calculated from calendar days, not in terms of the rules. It's provided by the Criminal Procedure Act. So applicants should be so guided, my Lord. And secondly, this notice which we have been given, if we read it, my Lord, it says he is going to apply for directions from this honorable court in terms of Section 32, subsection 4 of the Criminal Procedure Act number 7, Act number 1977, number 51 of 1977. Section 32, in the first place, is only 2 subsections. That's the first thing, subsection 1 and subsection 2. And Section 32 of the Criminal Procedure Act, which has been referred, it deals with the disposal of an item or article after a plea of guilt has been entered by an accused person. It has nothing to do with these directions.
Was it in terms?
It's written here. What I have given the paper.
No. The notice. I thought he said he gave notice in terms of Rule 32.
But it's contrary to what is in the paper which has been served upon us, which is written. It says.
No, I haven't. You see, I don't want to deal with. You see, when you make an application, I don't know whether I don't understand procedures here. You issue a process, isn't it? It's properly issued and you served. I don't know whether I can serve and then issue later. I prefer a situation where I handle a process issued by the court, isn't it?
Yes, madam.
Then we know that is formal. That's why I didn't mind him handing over, but I will have to look at a stamped process. Then I know exactly that I have got something that is formal before me.
In that case, then, my Lord, this is just a brotherly advice to him to cite proper legal provisions, not for us to waste time again in this court to take this paper to be issued by the registrar, because it means nothing. So he should go back and draft a proper application.
Your kindness is appreciated.
Yes, the court, please.
But anyway, the point I was making, that's why I was thinking of us meeting. I wanted the lawyers to consult. As I said earlier, there is an amount of disruption which can be caused to practicing lawyers, isn't it? In terms of meeting and doing all sorts of things. Of course, if everyone is now focused on this matter without other commitments, I'm quite happy. But this is why I was proposing that on Tuesday, whether Tuesday afternoon or Tuesday morning, we come after lawyers have consulted on the way forward, including the applicants in the section 319 matter, indicating that they wish to take it up. You see what I'm saying?
Yes, ma'am.
That's why I was thinking that we must meet on Tuesday.
Yes, ma'am.
For that purpose.
There's no objections.
And again, as I said, that the judgment which will or might be looking at the, what do you call it, your system on the computer, isn't it? The judgment to be delivered tomorrow concerning Mr. Tukulipi's application under POCA. As I said, that will be an important development, especially if he is granted the same relief as Mr. Isao. Then we will know that we are moving closer. You can see that in this case, the point I'm making is this. We are talking about 28 accused. Okay, we are talking about 10 individual accused. If the other 8, 9 are now ready to proceed, it's a matter I've got to decide how we proceed, even if one still has no legal representation. And forgetting not the point I made earlier that in any event, in the final analysis, as far as I'm concerned, a person will face trial despite certain challenges he might meet, because ultimately the criminal procedure is not optional. And that's why I was saying, let's meet on Tuesday. Let's not rush each other. I want you and the lawyers to consult, and the accused persons who are representing themselves get some understanding as to how we proceed, so we can at least discuss from a position of some understanding.
Yes, the court, please, madam.
My Lord, if I may.
Yes.
As far as suggested by the court is concerned, that we must meet, is it formally or in chambers, or what is the suggestion of the court in order for the parties to meet? And it reaches
Let me put it this way. First of all, so that you understand my approach. The recusal application has been disposed of, isn't it?
So noted.
This other application is, so far as I'm concerned, disposed of. But the applicants may decide that they want to take it on appeal. Then we know what is happening, isn't it? And then we can work our program around that as well. But assuming they are not taking this matter to the Supreme Court, then we work on a proper program for continuing with the trial. So that is the perspective from which I'm coming. So I was thinking that the lawyers and the self-acting accused persons and the state, I don't know how you can formally agree. I'm very averse knowing how things proceed now from my experience to get anything done informally. I would rather everything is done in open court. Yes, so that is why I was proposing Tuesday, just to come and say this is how we see things happening.
Well, I don't have a problem as far as the date is concerned. My only suggestion would be that we start prompt at 9 o'clock, because me and Mr. Banga Sumunja have already met her before your sister at 10 o'clock for continuation of trial. That is my issue.
But you know that starting proceedings here is always hampered by...
That is the reason that I raised the issue. But what I can do then in the meantime is me and my colleague then inform the presiding officer on Monday, maybe perhaps that we will then be delayed for an hour that we can commence with that matter at 11 o'clock.
Yeah, I'm simply saying it doesn't matter here, it seems, whether we say we start at 10, those who are in prison custody, they approach sometimes later than the agreed time. So I can't guarantee that even if we agree that it's 9 o'clock, isn't it?
I know.
We'll start at 9.
So noted.
But I don't know whether to leave it to you before I set a date, or let's say Tuesday is provisional
As the court pleases.
at 9.
As the court pleases.
If I get representation, then we can see what happens.
As the court pleases.
Yes, Mr. Shanghala.
Yes, Judge, I take note of the reference to the definition of days in the Criminal Procedure Act. Mr. Marondeze is correct. As regard to the inadvertent reference to the Criminal Procedure Act, I will correct the reference is actually to the rule. It states it's a rule. He's just taking a cheap point, but he may have his day. The point is, 4 days' notice is required. If the court waives those days and we decide to deal with the issue of the direction I seek, he can argue on that day that and help the court arrive at its decision in giving me the guidance. But I had reasons. I thought I'd laid them out in the notice, and that could be argued that day. Now the question is, if that happens, will the 2 hours suffice? Because, Judge, I for a fact am telling you now that I have given you the judgment of Luboya, Supreme Court judgment, and I've given you the judgment of Kautewa before. This attitude or approach, whichever is the appropriate word, if it's offensive, I withdraw it, approach or attitude. Some judges don't like the attitude. Shafimana didn't like it. If it is the attitude or approach of the court that you will prosecute me with or without a lawyer, it is totally wrong, and I have a problem with that. I have indicated that it behoves the
Shanghala,
court.
we can't...
No, you raised it. You raised it, Judge.
No, we can't be going back over a point I've made.
I agree with
If
you.
you don't, if you take issue with it, well, you know what to do.
Yeah,
the
no.
point of the matter is, and I can repeat it for you, for your
Yes.
sake.
Yes.
There comes a time when the trial must proceed. You agree with me?
Judge, I don't want to invite an argument.
Yes.
I just don't want in the future to be told, I've said it, you've said nothing. I'm just making it sure it's on the record that I object. That's it, that I do not agree with you. And then I will take it at the moment you say that, for example, I intended that, because first of all, Judge, you have to take it that I put a lot of work and effort under the conditions that I am in to bring the applications that I bring. I research them and under the conditions that I am in. I also cannot be at the same time litigating the issue of my legal fees and representation with those that I need to take it. I just cannot do it physically. I'm unrepresented. So I don't want it to be said that you are doing nothing. I'm doing what I'm doing now, which is still ongoing, and then I will deal with the other one. If that is now a delay, then by divination of the powers that you have, please, you can separate me, and I can do the other one, and I do the other one. But you can't. So I'm just making it sure that it is recorded that I'm not delaying the trial. I'm asserting my rights, and that is one of them, that I believe that you are wrong to say that trial will start notwithstanding. It would behove the court to even bring a graduate of yesterday to come and sit in a complicated case of this nature, because I just don't think that a surgeon can conduct a surgery over himself, even if that were desirable. But I've indicated that I will file the notice. It will be served tomorrow, and I can take it no further. It is please the court.
Yes. I've handed down my judgment, and I will make the usual order in regard to the continued custody of the accused persons except accused one. This matter is postponed to Tuesday at 9 o'clock. And unless it becomes unfeasible to meet at that time, the parties will be advised of a later date, not in the distant future. But otherwise, we are provisionally to meet here at 9 o'clock on Tuesday. The court adjourns.
It's Nipoka.